Okay, wow, good morning. We do have some significant updates in the parole in place litigation. It is Friday, October 25th, and I want to thank New Person for sending me the Supreme Court filing filed by the families and immigrants' rights organizations. Let's start there. The families, Oscar Silva Perez, as well as the other applicants that have been seeking to intervene, have filed an application with the Supreme Court of the United States, the highest court in the country, to stay the injunction that has been issued of the parole program. And a lot of the arguments made are, again, some of the same arguments that we have heard. Sorry, I'm looking at my notes here and doing this on the fly. The lack of standing argument was brought again before the Supreme Court. It outlines the legal grounds for the stay. And again, focuses on the injuries to Texas being, not being valid, essentially. So the families have asked the Supreme Court to pause the injunction. They've invoked what's called the All Writs Act in order to do that, as well as some Supreme Court rules granting them authority and governing emergency relief. Now, the bigger question is, when is the Supreme Court going to issue a decision, right? So Justice Alito oversees the Fifth Circuit, okay? Justice Alito could just issue a written opinion himself quickly, right? Within a matter of days or weeks. Justice Alito is not the most forgiving judge in this case, considering the interests. He could refer it to full review, certiorari, right? In that case, that's like a typical Supreme Court case where you have a very long timeline. There wouldn't be a decision issued for, close to a year. You could also have something called expedited full review. I think I'm looking here what the timeline on that is. It looks like it would be a couple of months, right? So a lot of different outcomes here. This is, again, an application to stay. It's not necessarily to intervene. It's to stay the injunction, which is great relief if granted. So that's what's happening at the Supreme Court level. Also, in the district court level, Judge Barker has denied the intervener's motion to intervene again. However, he has allowed them to file amicus briefs and make oral arguments at the trial. So what that means is they will be allowed to opine, to give opinions, to present a position without being a party to the case. So they're not going to be able to present exhibits or witnesses, but they will be able to weigh in orally with arguments, legal arguments, supporting DHS and supporting the parole in place program. So that's a sliver of good news there. Lots of updates today in the parole in place litigation. It's still, the morning on the 25th, so there could be more news later today. Thank you again for everyone sharing these updates with me so that I can, make a video as soon as possible after reviewing the documents.